Hello, this is Dr. Grande. Today I will analyze the case of John Moore and Tanner Mansell. First, I'll look at the background of this case, move to the timeline of the incident, then offer my analysis. This case takes place in Jupiter, Florida in 2020. At that time, a man named John Moore was captain of a charter boat and worked for a company called Florida Shark Diving. John was a free diver, underwater photographer, and former commercial fisherman. A deckhand named Tanner Mansell worked with John. Tanner was a shark diver and a cinematographer. Florida Shark Diving specialized in offering trips for snorkelers and scuba divers to view sharks in the waters off Jupiter Inlet. These waters fell under the jurisdiction of the federal government. Now moving to the timeline of the incident. On August 10, 2020, John and Tanner took 6 tourists out to sea in order to snorkel with the sharks. After completing the first dive, the vessel sailed toward the location for the second dive. At about 1:20 p.m., the crew spotted a large orange buoy, which was the marker for a set of commercial fishing gear. The buoy had writing on it, which also served as evidence as to its purpose. The buoy was attached to a long fishing line, which contained many hooks. John and Tanner told the tourists they had found an illegal long-line fishing line, which had been abandoned. This line represented a danger to sharks. As it turns out, the men were mistaken. The line was not illegal. A permit had been obtained by a man named Scott Taylor, who owned a vessel called Dayboat 3. He had obtained a permit from the National Oceanic and Atmospheric Administration to conduct research on sharks. Over the course of 3 hours, John, Tanner, and the tourists pulled over 3 miles of monofilament line, hooks, weights, and the marker buoy into the boat. The 2 crew members encouraged the tourists to video record the activity. The men freed 19 sharks and 1 grouper, which had been caught on the line. About 1.5 hours into this activity, John called a Florida Fish and Wildlife officer named Barry Partillo and informed him that he and Tanner had found what they believed to be illegal fishing activity in federal waters. John did not mention that the buoy was properly marked. At about 5:25 p.m., as John was bringing the vessel back into the inlet, Barry stopped him. Upon inspecting the boat, Barry did not see the orange buoy. He noticed that all the gear retrieved by the crew appeared to be new. For instance, there was no rust on any of it. The gear did not look like it had been abandoned. Barry told John to leave the gear on the dock so he could collect it later as evidence. John removed the hooks, attachments, and weights and allowed the rest of the gear to be thrown away at the marina. Both John and Tanner were present when the line was loaded into a cart and placed into a dumpster. Barry Partillo investigated and discovered that Scott Taylor had a proper permit and there was nothing illegal about the placement of the line. The federal government felt as though the removal of Scott's fishing gear represented theft. Scott was the victim of a crime. On May 5, 2022, John Moore and Tanner Mansell were indicted on 1 count of theft of property within the special maritime and territorial jurisdiction of the United States. The indictment alleged that the men, with the intent to steal and purloin, did carry away the personal property of another, having a value exceeding $1,000. They were facing up to 5 years in prison if convicted. Their trial was held in West Palm Beach, Florida. When the jury was given the case, they really struggled with it. They sent 7 notes to the judge saying things like, "We can't reach a unanimous decision." Could the judge define the word mistake? They were very divided. And were there any other defense theories related to the case? It seemed like the jury was trying to find a way to return a not guilty verdict. They were 1 step away from using their phone-a-friend lifeline. On December 6, 2022, John and Tanner were convicted of theft. In February 2023, the men were sentenced to 1 year of probation, and they were ordered to pay over $3,300 in restitution. An appeal was filed based on a claim of faulty jury instructions, but it was denied. Judge Barbara Lagoa concurred with the majority on the narrow issue raised on appeal, but wrote a scathing opinion about the decision to prosecute the men. She indicated that John and Tanner tried to save sharks from what they believed to be an illegal poaching operation. She wrote, quote, "They are the only felons I have ever encountered in 18 years on the bench and 3 years as a federal prosecutor who called law enforcement to report what they were seeing and what actions they were taking in real time. They are felons who derived no benefit and, in fact, never sought to derive any benefit from the conduct that now stands between them and exercising the fundamental rights from which they were disenfranchised. What's more, they are felons for having violated a statute that no reasonable person would understand to prohibit the conduct they engaged in," unquote. The judge indicated that Assistant United States Attorney Tom Watts Fitzgerald pursued the indictment for reasons that defied understanding. The weight of the evidence indicated the men made a good faith mistake. They never should have been prosecuted. The judge went on to explain how the theft charge in the case required that a person takes and carries away personal property with the intent to steal or purloin. The men never had the intent to steal or purloin. Despite the concerns, the appeal was denied, as I mentioned. It appeared as though the men would remain convicted felons. In a surprising development, this changed on May 28, 2025, when Donald Trump issued a pardon for John Moore and Tanner Mansell. A White House spokesperson said, quote, "President Trump has made clear that lawfare against any American citizen has no place in this country. This administration will always stand against egregious government overreach," unquote. Now moving to my analysis. John Moore and Tanner Mansell always maintain their innocence and have a large number of supporters. They argue that the men were simply trying to be helpful when they freed the sharks, and they were rewarded for their efforts through a felony conviction. The prosecution was uncalled for, heavy-handed, and ludicrous. The federal government, of course, disagrees. They believe that the men deliberately took the gear because having it there would lower the number of sharks in the area. They made their living showing tourists sharks. This brings me to the question, were John and Tanner guilty of theft? Let's take a look at the evidence both for and against the idea they were guilty, starting with the inculpatory factors. There is no question that John and Tanner took fishing gear that did not belong to them. They knew it didn't belong to them. The orange buoy attached to the line was properly marked. John had been a commercial fisherman. He should have known what that meant. Furthermore, there was no rust on the gear. John must have known it had not been abandoned. When John contacted Barry, he never mentioned the proper markings on the orange buoy. When Barry stopped John, he did not see the orange buoy in the boat. The tourist had taken photographs of the buoy. Where did it go? Barry told John to leave the gear on the dock, yet it was thrown in a dumpster. Both men were present when this happened. The prosecution argued that John and Tanner had a reason to remove the gear, saying, quote, "They want the sharks to be there. They get tips from the passengers. They get paying passengers to go out. They get nice video to put on their website. They get photos. But if a shark fisherman takes some of the sharks, maybe their job is a little harder," unquote. John removed the components from the line before the gear was thrown away at the marina. He was not taking it for his own use. The government never claimed he was. So why did he remove it? Perhaps John wanted to make sure that the owner of the gear would never be able to use it again. Moving to the exculpatory factors, the permit obtained by Scott Taylor to harvest sharks was one of just 5 such permits in the world. It stands to reason that neither John nor Tanner would have known that a person could even obtain this type of permit. Tanner would later say, quote, "I had no idea that this could be possible, that you could have a permit to kill all the sharks," unquote. John contacted law enforcement as the gear was being retrieved and encouraged the tourists to video record it. If John knew that he was committing a crime, why would he take those actions? Maybe because he believed he was collecting and dismantling unlawful fishing gear. When considering all the evidence in this case, do I believe that John and Tanner were guilty of theft? No, I believe they were not guilty beyond a reasonable doubt and not guilty in reality. They were actually innocent. They exercised questionable judgment, to be sure, but they did not have an intent to steal. What do I think happened in this case? This is just a theory, my opinion. John and Tanner were both very enthusiastic about protecting the shark population. People who do not care passionately about sharks would not enter this line of work. They may have been predisposed to see all threats to sharks as being illegal. When they spotted the orange buoy and realized it was attached to a fishing line that had caught sharks, they became angry and excited about the opportunity to disrupt this operation. Their bias towards seeing sharks as threatened led them to believe the gear had been placed illegally. There were a few signs they were wrong, like the name on the buoy and the lack of rust on the gear, but the men recklessly disregarded these clues. They were desperate to believe they had uncovered a massive illegal shark harvesting operation. The men should have been held responsible for the financial damage they caused, but not criminally responsible. They did not have any intent to steal. Two failures led the men to being prosecuted. Number one, incredibly poor judgment on the part of the assistant U.S. attorney. He was heavy-handed, legalistic, and punitive. This was a ridiculously weak case, which should have been viewed by the prosecutor as boring and petty, but for some reason he was very determined to make the men pay. Number two, the jury received bizarre and irrational instructions regarding the requirements to be found guilty of theft. The court instructed the jury that the defendants had the requisite intent to steal, or purloin, as long as they knowingly deprived someone else of their property. The words steal and purloin mean the same thing. Purloin is just a little fancier and sometimes implies a more surreptitious theft. Going by this description, simply taking something automatically means having intent to steal. That doesn't make any sense at all. It is not difficult to find an example where this would not be the case, even with the knowingly depriving part of the definition intact. For instance, imagine a customer who walks into a liquor store and sees an assailant robbing the store with a claw hammer. The assailant is waving the hammer around, demanding money, and saying things like, "This is a robbery." The customer knows the hammer belongs to the assailant. It's not like the customer thought the assailant took the hammer from someone else. He realizes the assailant is the lawful owner of the property. That element is not in question. If the customer wrestles the hammer away, he is knowingly depriving the assailant of the hammer. That doesn't mean the customer had an intent to steal it. This scenario is pretty much what happened with John and Tanner. They thought they were depriving an instrument of crime from an offender. There was no intent to steal. They never thought they were stealing anything. In their minds, depriving the owner was necessary to serve the greater good of protecting the sharks. Obviously, these men could have handled the situation better. They could have simply notified law enforcement without removing the fishing gear from the ocean. I do think the men were reckless in their disregard of evidence demonstrating the line was legally placed. But that is different than stealing. One lesson learned in this case is that making assumptions can lead to unpleasant outcomes. The second lesson is that the government can be heavy-handed and irrational at times. Sometimes prosecutors become intoxicated on their own power and demonstrate unbelievably poor critical thinking skills. This case could have been resolved by imposing a civil fine, or if the government was dead set on charges, deferred adjudication. Jumping directly to a felony prosecution appears to be nothing short of sadistic. Some of the pardons that Donald Trump has granted do not seem particularly well advised, but he made a good decision when he pardoned John and Tanner. The men were spared a lifetime of living as a felon. This is a shark more dangerous than any found in the water. Those are my thoughts on the case of John Moore and Tanner Mansell. Thank you so much for watching. I'll talk to you soon.